So I'll just quickly run through the rest of the presentation, and then I'll just open it for question. I think let's make it more interactive. So the liquidation process is pretty straightforward. If you look at the provisions, they're not very different from what you had under the previous regime. Just that the involvement of the court is very limited, and or the NCLT is very limited, and the fact that the entry point for liquidation is through this common funnel, that you necessarily have to exhaust the IRP process to get into liquidation. Okay, and the four main grounds are that you don't finish within the stipulated period, or if the COC decides to liquidate, this can happen pretty fast. The moment the COC is constituted, they can actually push the company into liquidation. If the NCLT rejects a resolution plan, then the company goes into liquidation. And then the last one, which is linked to implementation, where the corporate debtor contravenes the provisions of the resolution plan. That's also a ground for liquidation. Another point linked to the past. Under the Sikh Industrial Companies Act, it was possible for even if the BIFR made a recommendation for liquidation, that could still be litigated, and eventually a company could come back into the bankruptcy system for trying to explore another revival attempt. But that's not possible under IBC. Once there is a liquidation order, it's final. Under Section 11, it's clearly barred that a company can't enter the IRP process again if there is a liquidation order. So therefore, again, that's informed from past practice where people would try to explore restructuring revival despite there being some kind of liquidation recommendation or order. Then once a company gets into a liquidation, there is a public announcement. There is a new claims collection process, because obviously a lot of time has passed. It's possible that we are talking about, in some cases, the liquidation might actually be commencing after like 2-3 years of the IRP process. So you need a new claims collection process. There is a limited stay during liquidation as well. Here, one important point to note is that secured creditors are allowed to stay out of the liquidation process. This is the practice world over. So SARFAESI Act rights kick in again during the liquidation process. So they have the option to either enforce the security under SARFAESI, DRT, etc. outside, or relinquish their security and participate in the liquidation process. Going concern sales are possible in liquidation. The regulators actually come out with some regulations also on this, but in practice, it's liquidation is not the right place to attempt going concern sales, so therefore they're not really happening in practice, although there is an enabling provision for it. But now that the law has clarified that COC can decide to push the company into liquidation on day one, there is a possibility of structuring some deals where you do a going concern, you decide that there is value in the company, but instead of waiting 180, 270 days, you identify a buyer, push the company into liquidation and sell it on the same day as you push it into liquidation. So this is the closest you can get to a going concern and resolution practice in other jurisdictions. So I don't know how this will evolve, but there is a possibility now of doing these going concern sales and liquidation. Just like the resolution professional in the IRP, the liquidator also has the powers to go take actions for preferential, undervalued, and other transactions. Again, very little practice on this. Not much used in practice, and the question again is that why would somebody throw good money after bad? Because every prosecution that you initiate involves costs, and those costs will be taken out from the proceeds that will be distributed to the credit stakeholders. So we haven't really seen much action on that front. The liquidator has the flexibility to sell the company's assets in a public auction, or and then if through a private arrangement if public auction fails, or if the goods in question are perishable. In most cases, there is flexibility for the same person who was handling the case as an IRP to continue as a liquidator, but now the law has changed to say earlier he had no flexibility, he had to necessarily continue, but now his consent is required. before before he decides to continue as a liquidator in the liquidation stage. Again, I should have pointed this out for the previous section. The COC has the flexibility to determine the fee of the resolution professional. So this also makes it very market driven. That's why you're seeing that a lot of these big four type of IPs who are taking up these assignments, which are actually helping in effective resolutions. That same flexibility is there in liquidation also. However, you have detailed regulations on fees for the liquidator, unlike in the IRP process, which is where it is completely market driven. Here, there are some regulations on how that fee will be calculated, and you have the success fee mechanism, where there's this entire table which you probably would have seen it, that if you're able to sell it within a certain period of time, then you can take a higher commission, and basically it reduces with time. So therefore, the faster you sell it, the more money you make. So that's to incentivize a liquidator to try and sell the assets as soon as possible. And then there are regulations on the kind of reports that you need to submit to the NCLT, because you need to submit this progress reports to ensure that, because there is no, unlike the IRP process which has to finish within 180, 270, there is no outer timeline for liquidation. There is this outer timeline of 2 years, but this is, how do you enforce that? Because what is the consequence if you don't meet that timeline? Unlike in IRP where you don't follow, you get into liquidation, but if you don't finish liquidation in 2 years, then what happens? So there is no consequence, so to speak, but the only reason this might work is because you have this fee tied to the speed of the process. So possibly if the liquidator asks fast, he'll make more money. So that could actually help in speeding up the process. But other than that, there is no other driving force, so to speak. This last point is important. The liquidator is pretty much on his own during the liquidation process. This is very different from the IRP process where COC oversees and COC takes all the call. Here, liquidator is much more powerful in comparison. He can consult the creditors and other stakeholders, but their advice is non-binding. So this is a big kind of change in comparison to the IRP process. And again, this is informed by, it's a conscious choice, because even the creditors, they should make best attempts to try and resolve during the IRP process, because they will also lose control if the company were to move to liquidation, right? So this will also incentivize them to not, because they would not ideally want a company to go into liquidation, because they will also lose control. So, but there is a lot of criticism of this move, of this provision, and you might kind of see some kind of a COC for liquidation also in the next set of amendments, because people are saying that the liquidators are not doing their job properly, they're not taking into account the interests of creditors, they're acting on their own. So we might see some kind of a correction here, but the challenge there would be that if COCs are given a role in the liquidation process, then they might game the entire system to first exhaust the IRP, then get into liquidation, and then basically try to do the same thing in liquidation, and this might cause delays and problems. So I don't know how this will actually play out. Now this is the distribution waterfall. I guess you guys have a session on this specifically very soon. The cost of IRP and liquidation are right on top. Then you have workmen's dues for 2 years, and debts owed to secured creditors, which are right. So here only secured creditors who have relinquished their security. So it's basically to incentivize them. So they can always enforce it outside, but if they don't, then they'll be paid before anybody else. So this is to incentivize them to participate in the liquidation process. Then you have employee dues for, that's 1 year. That's a typo. That's employee dues for 1 year. And then you have unsecured financial debts, which is over the government dues. So this is actually a big change from the past, because government dues actually came on top of all unsecured debt in the past. So now this has been pushed under unsecured financial debt. This is actually a big change. And the question really was, because we have so many public sector banks and they have such huge NPAs, so essentially the government had to decide between NPAs and loss of revenue in tax, etc. So therefore, they took the call that we need to put government dues below the bank dues and financial other unsecured financial debts, etc. Then whatever is left comes right after that, and then you have preference shareholders and equity shareholders. Now this last piece is again an interesting academic question, because especially now that the law says that a plan, if it meets if it distributes the proceeds in accordance with section 53, it will be deemed to be fair and equitable. If you have a plan where the going concern value is so good that even after distributing all these proceeds, you have some equity left, then you will actually have to distribute that to the existing promoters if you follow the waterfall. So you see my point. Like currently what happens is that the promoters' equity typically gets wiped out, and whatever they decide in a resolution plan, they organize the company. Like in Bhushan Steel, it got acquired by Tatas, and they are the new owners, etc. But if you were to follow 53, there might be a situation, it's a hypothetical situation, where the going concern value is so high that after distributing it to all the creditors, you still have positive left at the end, which will then have to go to the shareholders, equity shareholders, who were equity shareholders at the time of filing, not the new ones. Right? So this is the waterfall that you now follow for IRP also, for the resolution plan also, post this amendment, the latest amendment which has happened. So this will have to be examined carefully.
I've got one question there.
Yeah.
For instance, like we've been discussing the UB case in detail, and there was an investment there which was being made by Diageo, which was stopped in terms of because of it being admitted, Kingfisher and UB being admitted for winding up. Now, under the new law, if you're still going through the resolution plan process, is a buyout possible? Because I didn't find anything which said yes or no to the effect. My logic would be yes.
See, a change of control is entirely possible. So therefore, as long as the entity is the same, right, a full buyout is possible, and you've had some cases where the employees have actually come together and submitted bids for a buyout. Right. I'm not sure whether a leverage buyout has been attempted in the Indian context, but but change of control is fully possible. Now, obviously, that's happening in most of the cases, yeah, but a very structured type of a buyout may not be possible, where you kind of separate assets and say that you'll only buy these parts and not those parts, etc. Because you have to actually resolve that entity. Going back to that discussion on resolve the corporate debtor as a going concern. So you have to resolve the same guy as the going concern. It's an unfortunate interpretation, because that was clearly not the intent. If you look at the notes and clauses, it says that it says that you have full flexibility to resolve as you please. But that is a limitation to the kind of structuring that you can do. Eventually, you have to say that you resolved that debtor as a going concern, and then within that you can do whatever. Okay, so that's the waterfall broadly. Now, there are some other actions under the code which have again not been utilized much, but they're really powerful provisions. If somebody has filed a case maliciously, he can be penalized for up to 1 crore, right? So therefore, this is to disincentivize people from filing just for the heck of it without there actually being a default. So, and I understand that in some cases the NCLT has actually imposed penalties on some people. Then there is this provision on action for fraudulent trading. So therefore, if and this is actually a civil provision, so therefore it's not fraud as defined under the Companies Act, and therefore you don't have to kind of prove it beyond reasonable doubt. If you can prove that the business of the company was being conducted fraudulently, then you can actually go after the promoters and get money out, get money from them, and there is no cap on liability whatsoever. So technically speaking, if there is fraud in a company, then the IP can file a case to get some money back from the promoters. and there is no cap on liability whatsoever. And then there's this provision on wrongful trading. Fraudulent trading and wrongful trading, they're both embedded in section 66. Wrongful trading is actually one level lower. Like fraudulent trading is, you still have to kind of prove fraud. Wrongful trading, you don't even have to prove fraud. You just have to prove that the company was mismanaged. The directors knew that it is under financial distress, and yet they did not act soon enough to protect the interests of the creditors. So it's even lower. Again, untested, but gives a lot of power to IPs, creditors, etc., to try and get these cases initiated for holding the promoters and directors liable, personally liable. Like conceptually speaking, like in the Kingfisher case, forget about even if there was no, assuming that there was no fraud, even if there was mismanagement, and even if there was negligence, just to give you an example, conceptually, if at the time when new loans were being taken, they knew for a fact that the company is not viable, then under this, the promoters and the directors can be personally liable. So this is a check, basically, to ensure that going forward, people are more disciplined when it comes to taking loans, and they make appropriate disclosures at the time of taking loans. Otherwise, they can be personally liable under these provisions. Again, these are not tested. Even in the UK, these provisions have been taken from UK law. They've been because this wrongful trading provision has been on the statute books in the UK for a very long period of time, since 80s, if I'm not wrong. But there have been only 22 successful prosecutions, which means that it's difficult to prove in practice, but you have this check. Yeah.
Like the applicant who is submitting the bid, wouldn't that company need the entire control of the?
That is happening in every case, but I'm saying the entity can't change. Like you can't do a structured buyout where you say that you split the.
Shareholding will change.
Yeah, so shareholding will change, but now there is this new amendment I should have clarified, which allows you to do schemes. So now, if you read that amendment along with this, then you can say that if you're doing a structured buyout as part of a scheme, then maybe you're allowed to do that. But I think it still needs to be tested, because unfortunately the NCLAT ruling is very specific. It says that you have to resolve the debtor as a going concern. So whatever you do it as part of that entity.
So in our examples, essentially,
Yeah.
in our example, remember when we were talking about piecemeal sales, we were talking about whether we can sell this part of the company and that part of the company. Essentially, you can't do that. If it has to be like it can be an entire just control change, but the company can't be broken apart into multiple entities in piecemeals. That's the issue.
You are allowed to sell like some assets, but only in limited circumstances, and not for like resolution. Like there is a cap on it should be like less than 10% of the overall value of assets, etc. But only for like something is perishable or so on and so forth. But otherwise, you have to resolve that entity.
When there is a change in shareholding and all by the resolution act, should there be an interview by the SEBI takeover code also?
So there's an exemption that the law, SEBI has amended its regulations to say that if you're doing it under a resolution plan, we exempt you from takeover obligations. I'm not sure if it applies to all deals, but just check that. So.
SEBI and public company questions. I'm
Yeah.
just saving you, boss.
No, but there is an exemption. I'm not sure whether it applies to everyone. That you'll have to check. Yeah. So the Insolvency Law Committee, this was basically the second reform committee which was set up. They came out with a detailed report in 2018. A lot of amendments that happened, the major amendments that happened were based on the recommendations made by this committee. And some of the things that some basic things got clarified there. Like they've clarified that intention is not relevant for default, because a lot of people were saying that I was driven into bankruptcy because of extraneous circumstances. Why am I being punished? Like it's a commercial thing. If you've defaulted, you have to enter the bankruptcy system. So therefore, intention is not relevant at all. The home buyers piece was explained in detail in that report, saying that as to why are we giving this treatment. 29A, I should have actually talked about it in the IRP process, is basically it debars certain kind of people from submitting resolution plans, and that's largely essentially promoters, etc., who have uncleared NPAs, who contributed to problems, etc. So they are prevented from submitting resolution plans. This provision was not there in the original IBC, because the logic was that if the creditors have to decide ultimately, why should we exclude anyone? Let anybody submit and let the creditors decide. But they realize that if the promoters are involved, it might kind of give them an upper hand because they already know so much about the company, and and this was actually, the constitutional validity of this was tested and it was upheld with limited changes. So ILC, because 29A was done by an ordinance originally, and then they kind of reformed that and refined that in the ILC process, after the ILC process, and now we have a much more refined version. Yeah.
Isn't this provision too broad, Section 29?
It's very problematic to be honest, because I personally feel it's not required at all. So because as I said, it's the COC which ultimately decides. So what's the point of barring people? Let the COC take the call. Let everybody submit and let them take a call. I don't think this is required.
In case of that Adani, Ruchi Soya and all, that
Yeah.
Adani was not allowed because one of the promoters' father-in-law.
Yeah, I know.
was-
And then the law was changed also, which kind of addressed some of these issues. So especially I think that relative issue got sorted by the amendment and by the clarification that the Supreme Court made. But broadly, you would conceptually just look at it. It's a promoter has no say in the COC, right? So when you are barring him from submitting a plan, I don't understand, because this will only help in value discovery, right? The only strong point in favor of not having them is the fact that obviously they have more information than any of the bidders. But I think this is also a good research question. Can we think of some kind of a because in a lot of cases, you don't have successful bids, right? And in those cases, should we bring them back and say that there are no bids now? Let these guys come back and make some bids, because it's better than sending the company for liquidation, right? But this is an academic question.
Wasn't there a recommendation that there should be an information committee as well, so that such a problem where there is a information mismatch between the promoter and the creditor, so that can be avoided? And I don't think that's there something.
No, so you see the information asymmetry problem has been underscored by a lot of people, and but unfortunately, because of the 180-day, 270-day window, there's not a lot that can be done. You can't compromise the deadline and say that you do a proper diligence and figure out the best possible valuation and then submit. You have this window within which you have to act. So unfortunately, not a lot can be done there, and it's basically the quality of the resolution professional. And if he is able to get a very good information memorandum prepared, which is the basis for submitting these bids, then that's actually the best thing that that can be done, and really can't go beyond that.
Wouldn't an information compendium would help the creditors before, or anyone who wants to file them insolvency proceedings or wants the IRP just to come in? Wouldn't it actually help them first to get to know how they can go about it, or whether the company is actually, where is it working at? Like you said that sometimes the default is the first stage and not the last stage as we used to see in the previous acts. So wouldn't that go a long way?
So you have an information memorandum, IRP, before it invites bids, it has to, the IP has to prepare an information memorandum, and whoever is interested in submitting bids has to take a look at that information memorandum and then make a bid based on that. So there is this information memorandum which gets prepared, but obviously it can't be compared with the kind of diligence you would do if you were to do this outside the IBC. So therefore, that's the point. And So therefore, it's a risky investment for everyone. And therefore, but for them, the advantage is that they are buying some of these companies, some of these resolution applicants at deep discounts. Like the possibility of an upside is huge, and because they're getting the positives without the negatives. So therefore, people are investing and investing some of these companies. Now there is this provision for withdrawal. There was some confusion on whether a case can be withdrawn or not. So now it's been clarified that it can be withdrawn only with the approval of the Committee of Creditors, and that too 90% of them by value should have approved. Otherwise, a case can't be withdrawn. Because this was also a big problem in the past, that a case would be filed, and then some creditors, the guy who has filed the case would, his debt will be paid off, and then the case will get withdrawn. So this used to happen a lot under Companies Act. So in order to get around that, because once you have initiated, then it should basically be taken to its logical conclusion. And only if 90% of them say that you have to withdraw it, can it be withdrawn. IP remains responsible for statutory compliance during the process, like all the Companies Act type of requirements. And he has to manage the firm till final approval of the plan. The two, Joint Parliamentary Committee had kind of made two big interventions. Earlier in the original bill, there was a provision that the IP had to submit a performance bond before taking an assignment. And this is based on UK law, because he's taking up such a huge responsibility. So there should be some liability on him if if there is a problem. But the JPC felt that it's just too early in the Indian context. You don't have a market yet. Let the market evolve and bring this provision back. So therefore, this provision was removed. They also ensured that we have these lot of funds for the benefit of employees that a lot of these companies have, provident fund, other employment benefit funds, etc. So these have super priority over the waterfall, like because this is essentially the money that belongs to employees. So all of this has to be paid back. There is no cap at all. All of this has to be paid back, and you start distributing after everything has been paid out of this. So this is again a clarification that JPC made and ensured that the law specifically provides for it. So broadly, that's the corporate. I have not taken you through everything, because I understand that you'll go through the details in some of your more details. I just wanted to give you a broad overview and some of the design thinking that went into the drafting. I'm happy to take any questions, but I just have this last slide on personal insolvency because you obviously have like most of the IBC provisions, like in terms of numbers, are on personal insolvency, but they haven't been implemented yet. And the biggest problem is because the DRTs, which are supposed to be the adjudicating authority for this part, they're so overburdened right now that the government is just not in a position to get these provisions notified. And also you don't have like an NPA crisis type of a situation for personal loans, or personal debt. So therefore it's not like an immediate concern, at least doesn't seem to be an immediate concern. So broadly, it's split into three parts. You have a fresh start process, which is for people below a certain income and asset level. Then you have insolvency resolution, the regular IRP process, and a bankruptcy process, which is the equivalent of the liquidation process. It's called bankruptcy and not liquidation for individuals. And because it's the policy objective for individual bankruptcy is different from corporates, because you obviously can't liquidate a human being. So the idea is that you have to give this guy another chance. So therefore, it's more humane in that sense. You have to first exhaust the IRP process, and it's kind of balanced. Both sides have to agree, and it's more facilitative. So it's not like it's not like a recovery proceeding. It's more it's a more balanced, so to speak. It's very clear that the corporate system is loaded in favor of the creditors, but you can't say that for the personal process. Yeah. Now, one major point of interaction with the corporate process is personal guarantees. Now, obviously, for personal guarantees, because those are guarantees given for corporate debt. One might think that the policy objective should be the same, but the idea is that you have to give this guy another chance. So therefore, it's more humane in that sense. You have to first exhaust the IRP process, and it's more facilitative. So it's not like a recovery proceeding. It's more the objective is the same. Even for a personal guarantor, you have to follow the same process. You have to give this person another chance. Just that the adjudicating authority for such cases is the NCLT and not the DRT. So one might see those provisions being notified sooner. But again, it's not like a recovery thing. You can't get the assets out, and it's not a creditor-driven thing. So it's basically to give that guy another chance. So that's broadly the personal insolvency piece. Yeah, and happy to take any questions. We have another 15 minutes. Yeah, sure.
Under the fresh start process,
Yeah.
the loans are waived off.
See, that's it's actually the terminology for personal insolvency is discharge, okay, and it's not like an automatic discharge. If you look at the eligibility criteria, it says that your annual income should be less than 60,000 rupees, and your annual income should be less than 20,000 rupees, and your assets should be less than 60,000 rupees. So it's a fairly small kind of a number, but at the same time, if you look at the microfinance industry, a lot of those loans will easily get captured by this. So the concern is that, are we incentivizing people to default and say that, I'll take this loan, but the moment there is a problem, I'll just go get a discharge and get out. That's not the case. There still be an adjudication. The DRT still has to take a call on whether this guy actually deserves a discharge or not. They'll take a look at his assets and liabilities and take a call. So it's not like a waiver process. In fact, one of my colleagues, Aishwarya, who works on the personal insolvency piece, she's actually from your law school. She wrote a piece in the Economic Times earlier this year, where she kind of explained that this entire farm loan waiver thing that happens just before the elections every time, it's a very economically inefficient way of handling this. All that should be routed through the bankruptcy system and through this fresh start system, because it's a more objective way of doing it. It's not political. You follow a full administrative process for that. So let's see whether that happens. I think government has made a commitment that they'll start the fresh start piece very soon. Let's see when it happens. Yeah.
So in the future, as we've seen, there'll be multiple cases on certain people who have given credit to the company come and be labeled as some sort of a creditor, like a financial creditor, so that they have a role in the proceeding.
Correct.
So according to you, like your opinion, what criteria should the courts use for to classify them or to recognize as to whether these people should be financial creditors or not?
See, I think conceptually, if you look at the definition of financial debt, it's fairly clear. So therefore, only people who have given money for the time value of money should be considered as financial creditors. But unfortunately, this home buyer situation has created a problem. And as I said, it will be actually, if some people start, filing these cases and say that I am also a financial creditor using the home buyer logic, then there will be a problem. But Supreme Court has upheld the home buyer situation. I actually don't have a clear answer for that, but I'll go back to the definition, which is very clear. I don't know how can you classify the money that home buyers give as financial debt.
So then follow up. So basis this definition of financial creditors, financial debt, you see certain guarantors also who paid money to be made financial creditors.
Correct.
But the courts have again and again reiterated the fact that guarantors should share a liability equal to that of creditors. But
See, actually, there I kind of agree with the courts, because she also teaches contract law, so she is the right person to answer this. The liability of guarantor is coterminous with that of the principal debtor. So that law is very settled. So therefore, if there is a financial debt which is guaranteed by another guy, so that guarantee will also be considered to be a financial debt. So there is no doubt about the fact, but you can't have double recovery. If you have recovered money from one guy, then you can't go after the guarantor. And I think there is some case law recently which has said that it doesn't say that you have to exhaust the remedies. You can proceed against both simultaneously. But once there is recovery, you can't double recover. You can't double dip.
But say you recovered the money from guarantor, but then guarantor proceeding against the person under the IBC, the provision is not there.
No. So that too is done. No, because if the money is recovered, then the guarantee, the underlying reason for invoking the guarantee does not exist. So therefore, on day one, the petition will be rejected. You see my point?
Sorry, and you're confusing personal guarantors and corporate guarantors. They work very differently. Yeah, personal insolvency, there's a carve out. So if you have any specific questions, we can talk about it. It's not a part of your curriculum. But I mean, there's confusion there in terms of example. So we can get to that.
No, but I think even for corporate guarantees, like if the money has been recovered and there is a corporate guarantee, then you can't go against the corporate guarantee, the guy who has given the guarantee, because you already recovered the money.
Corporate guarantor, the corporate guarantor go against the principal debtor.
Now you're talking about.
Oh, you are saying the back?
Just completing the circle.
Yeah. So that obviously depends on the relationship between the principal debtor and the corporate guarantor. So it's underlying the contract that they have. It has nothing to do with IBC.
It's just pure indemnity.
But
Yeah.
So,
That's a suit.
okay, so a corporate guarantor in this situation cannot come forward and initiate a CI proceedings for the resolution plan.
No, technically so. Till the time, so basically, the moment he honors the guarantee, he becomes a creditor, and it depends on where the proceedings are. So, the moment he becomes a creditor, then obviously, then he, depending on where the proceeding is, he can file a claim and say, I am also a creditor now. But depends on when it happens actually. Because he's not a creditor till the time the guarantee is invoked.
So now in initial illustration, the case that we did, the corporate guarantor with you till there is a default payout, will continue to maybe be an operational creditor by definition. Yeah, maybe because you have stake involved, etc. So maybe by home buyer's logic. Yeah.
Yeah.
Sorry, Rohan will wait.
Yeah.
Sir, so sir, most of the provisions, even the initial provisions of the Act and what ILC suggested in 2018, I think most of them are focused on making the process more swifter and quicker compared to SARFAESI and SIG Industries. And
Correct.
etc. But so what I wanted to ask is then, if that is the case, then why didn't the ILC even in 2018 consider something like pre-packaged insolvency, which is there in US, in Chapter 11 and even in UK, and it has been used, like a considerable amount of litigation is focused on pre-packaged. So why don't we think that our market is mature enough?
So I think it's a very good question, but we have to examine the context. Again, this is linked to our political economy. Pre-packs works beautifully in the UK because the nature of the banking industry is very different. You have typically very few lenders, and you don't have promoter-driven companies. So lenders, as a matter of practice, are able to track borrowers very closely. They have much greater role in more involvement in the business. So the moment they realize there's a problem, they can quickly come together and do a pre-pack, and find a buyer, sell the company very fast. But in the Indian context, you have like these consortium loans where like 15 banks will come together, and public sector, private sector. So and they're not as deeply involved, and you have promoter-driven companies which operate very differently. You don't have as much information sharing, whereas there you have largely professional managers, etc. So the lender community and the borrowing community acts very closely. So in fact, you would see oftentimes there you would see both acting together to get a pre-pack done. So whereas here you have different sets of challenges. It's almost impossible to have a pre-pack done without getting the promoters on board, right? And why would the promoters want to sell the business? Like they've worked hard to get it wherever they've had, wherever they have got the business to, and now we are saying that now you want a deal where you will sell the business off and settle the debts. So I think in the Indian context, it will be very difficult to attempt without displacement of management. So therefore, maybe for professionally run companies it's possible, but given that most of our large companies with large debt are promoter driven, very difficult. But we are actually doing a concept paper right now on this and as to how to design this in the Indian context. It's an academic paper. I don't think it will. You can provide an enabling provision, but because of this challenge, that it might work for the only reason where if you design it in a way where you give the promoter some kind of a right of first refusal. You say that, okay, boss, creditors will say this company is going down, you need to cooperate with me to sell it to a third party. We'll identify a buyer. If you're able to match that price and take the company and get us out. If not, I'll have to sell it to others. But the promoter will have to agree. And I think the way it might work is they'll say that if you don't cooperate with me, I'm going to push you into bankruptcy tomorrow. So that might be a solution, but I don't think we can adopt pre-pack as is in the Indian context because of our political economy. Yeah.
Sir, there was this thing that there's effective pre-insolvency bilateral workout mechanism. So do you think that might also be an option going forward with the IBC?
Sorry, I didn't get that. Can you say that again?
An effective pre-insolvency bilateral workout mechanism between the creditors and the debtors, whoever the concerned parties are at that point of time. So does that somehow make sense before actually going into the insolvency?
So I think he's asking about debt restructuring outside the IBC, and you're saying bilateral.
Yes.
And in the Indian context, you have an RBI circular dated June 7, which basically says that banks which are regulated by the RBI can come together to basically try and agree on a resolution plan before filing a case in the IBC, especially for loans which are beyond a certain number. So that possibility is there. You can resolve outside the IBC, but the key concern there is that there is no finality. So one might say that because you have this IBC threat, promoters will cooperate and they'll make sure that they cooperate in any such out-of-court restructuring. We've had cases in the past where before the IBC came in, you had something known as CDR, corporate debt restructuring, where promoters would just sign new deals every 3 years and never honor the past deals. But with IBC, the thing is that if they don't honor the past deals, they can be put into IBC. So therefore, possibly these kind of debt restructuring mechanisms may work. And in fact, you should ask the practitioners. I understand that a lot of cases are being resolved outside the IBC because of the threat of IBC. And there is no data on that. But the fact of the matter is that this is, it's actually working better, even better than, the IBC itself. So for all you know, there might be a lot of deals happening in this under this RBI framework which people don't know about. So I think that is something that you guys should definitely ask the practitioners, because it's not that we didn't have debt restructuring in this country in the past. We had a pretty much defunct bankruptcy system, but it's not that there was no debt restructuring, just that they were not being honored. But my understanding is that because of IBC, you all these out-of-court restructuring packages are being honored, but there is a limit to what you can do outside. You can only basically take haircuts and say that you can't resolve completely, and at least in theory, I would say, why would a promoter want to give up control outside? Well, file an IBC case against me. But it can work the other way also. The threat of IBC will maybe make him to cooperate and say that, okay, do whatever you want, but don't push me into IBC. Okay. Thank you. Thank you so much. Thanks.